Okay, so in this video, we're going to talk about 10 provisions every revocable living trust should have. So I'm Paul Rabelais. I'm an estate planning attorney. Every morning at 10 a.m. Central Time, check into this YouTube channel where I'm going to give you another educational video that will help you protect what you have for yourself and your family. All right, I want to give you a little bit of introduction to this topic and then jump in to the 10 necessary provisions. Okay, when people get their legal affairs in order, they do several different things. Yes, they provide for where their stuff will go when they die, how they want to leave it to their spouse if they're married, to their children if they have children, to grandchildren, to others. And that all is very necessary and very appropriate. In addition to designating, how things are to be distributed when you pass away, many people also want to simplify or streamline that process of getting their estate settled. So many people, instead of using a will or last will and testament to provide for where their things go when they die, and when you use a will and you pass away with assets in your name, your assets are frozen, and the executor or other family members will hire lawyers like myself to guide the family through a court-supervised process to have things transferred from your name to your heirs. Many people perceive that as being very difficult, expensive, and time-consuming. They probably perceive it because it can be all of those things. So in order to eliminate all of that lawyer and court involvement in the estate settlement, many people set up what we call their revocable living trust. And during their lifetime, they transfer the title of assets that they own to their trust. Things that are in a trust when you die, they don't get frozen. They don't go through the court process. You'll name probably a family member to be the trustee of your trust after you pass away, and then they can immediately disperse things out of the trust to your heirs or beneficiaries without any court or attorney involvement. So that's the idea there. There's lots of videos that I've made on kind of the ins and outs of using a revocable living trust. But when one uses a revocable living trust, or if you use a revocable living trust to, in essence, replace your will and allow for the settlement of your estate without going through the courts, then there are 10 provisions that should be considered or should be in your revocable living trust. So let's go through those. And before I go through those, just a quick reminder, make sure you hit the subscribe button along with the notification bell. That way you won't miss anything. And if you felt like this provides you with some value, give it a thumbs up. And if you want to contribute with some comments below, feel free to do that as well. All right, let's roll here. 10 provisions that every revocable living trust should have. Number one is, and another little issue here, I work as a lawyer in Louisiana, and I've helped many thousands of clients over the last 28 years get and keep their legal affairs in order. And so some of these things I'm going to go over are state specific, and so you may need to check with someone if you're not in Louisiana. Most of what I'm going to go over is general, but there's a couple of provisions that could be state specific. The first one in particular. So you want to make sure that in your revocable living trust, you state that your trust is revocable. So here in Louisiana, that's why I brought up the Louisiana thing, our trust code says that a settlor is you or the person who sets up the trust and transfers their assets to the trust. Our Louisiana trust code says a settlor may revoke a trust only if he has reserved the right to revoke the trust. So in your trust, you have to say, this is a revocable trust or something to that effect. Number two is you'll want to designate the trustee of your trust. In the traditional or customary revocable living trust, you will name yourself as the trustee. Perhaps if you're married, you'll name you and your spouse as the co-trustees, and then after one spouse dies, perhaps the surviving spouse is the sole trustee. So you'll need to designate those trustees, but not only name yourself as the trustee, you want to make sure you name a successor trustee, because the trust is going to last for some period of time after you pass away. Because when you pass away, there's that process of transferring the assets out of your trust to your trust beneficiaries, may call it your heirs, and it's going to take that successor trustee that you name in your trust instrument to do that job of dispersing the trust assets to the trust beneficiaries in accordance with the trust instrument. So number two, trustee designation. Number three, Designate who the income beneficiaries of your trust are. Again, in the customary revocable living trust, you will be what's called the income beneficiary for life, which means if your trust assets produce some income, whether that's interest income, dividend income, rental income, if you are the income beneficiary of your revocable living trust, which you probably should be, then all that income goes to you. And kind of, oh, by the way, on a revocable living trust, the trust doesn't need its own tax ID number. The trust doesn't have to file a tax return. You'll still report that income on your personal return. So the trust is really ignored for tax purposes. You still report all of the income on your personal return. So you'll want to designate who the income beneficiaries of your trust are, and you'll likely appoint yourself as the income beneficiary, and then maybe you'll have successor income beneficiaries, particularly if you want to designate or be specific about who gets the trust income after you pass away. Number 4 is who are the principal beneficiaries. So trusts have 2 kinds of beneficiaries. I mentioned a moment ago, you should designate yourself as the income beneficiary for life. And then you'll designate your principal beneficiaries. Who's going to get the trust assets when you die? And maybe you just say, my children are equal principal beneficiaries. Maybe you say, as to $25,000 of trust principal, that will go to my church, and the remainder of the trust principal will go to my children. Or maybe you'll say, I want 20% of the trust principal when I die to be divided equally among my grandchildren, and the other 80% to go to my children equally. So there's really no limit on what you can do there, but you need to designate your principal beneficiaries. That's really important. Okay, and then number 5 is the trust term. I would say in the typical revocable living trust, the trust gets wound up after you die. And that successor trustee that we talked about, maybe the successor trustee is one or more of your children, either as an individual trustee or as individual co-trustees. That successor trustee, right after you pass away, will be in a position to immediately start dispersing assets out of your trust to the principal beneficiaries. Occasionally, and it's not uncommon for your revocable living trust to live on after you die. Perhaps you have young children that, and if they're 12 when you pass away, then that trust should stay in existence so that they don't get the inheritance, and it goes on until maybe they're 25 or some later date, and you authorize, that child's share to be used for their health, education, maintenance, and support perhaps. So oftentimes trusts terminate when the settlor dies, but sometimes they go on for many years after that. Number 6 provision that should be in every revocable living trust is a spendthrift clause. And this is really applicable in the revocable living trust scenario from the time that you die until assets are dispersed to your beneficiaries. And particularly if there's going to be some time period that will take place from when you die to when the assets are dispersed to the appropriate principal beneficiaries. But what a spendthrift clause does is it says that in a revocable living trust, it says after you die, then a beneficiary can't sell or alienate or mortgage his or her interest in the trust. A creditor of the beneficiary can't seize the beneficiary's interest in the trust. So, just about every trust has those spendthrift clauses. Those are a good thing. All right, number 7 is a provision dispensing the security requirement for the trustee. Here could be another state-specific item. Here in Louisiana, if you name an individual trustee to handle things when you pass away, an individual as opposed to a corporate trustee, then that individual has to post a bond or furnish security, which is a real nuisance. Unless in your trust instrument you waive that bond requirement or you dispense with the requirement that an individual trustee furnish security. So you're going to make sure you do that. The next one is really an optional provision. By saying these are 10 provisions every revocable living trust should have, that's kind of a stretch for this number 8, which is the no contest clause. So some people who kind of foresee there may be issues when they die because maybe their children don't get along, or maybe their children just aren't real responsible, relationships aren't great, maybe children have spouses who make things difficult. We get asked, can we put a provision in our trust where if anybody contests anything, they don't get anything? So another state-specific area. But a lot of people who set up trusts, they like that because they don't want to encourage family conflict. They want to discourage it. And perhaps when a beneficiary who is thinking about trying to initiate legal proceedings to invalidate a trust or invalidate a provision of the trust, if they see that no contest clause in the trust, they may think twice about raising a concern that they otherwise might raise. All right, number 9 is again a Louisiana thing, but we want to make sure that the trust is what's called an authentic act. So at the end of the trust, there's all the language and all the signature pages so that you sign before a notary public and in the presence of 2 witnesses so that your trust meets the formality requirements of an authentic act. So that really needs to be in every trust. And then my 10th and final provision that should be in every revocable living trust, kind of with an asterisk, is there should also be what's called an extract of the trust. So this is if your trust owns real estate, and many revocable living trusts own real estate because many people who set up revocable living trusts to make the estate settlement easy, many of those people own a home, so they put their home in their trust. And if a trust owns real estate, another Louisiana kind of specific thing, then what's called an extract, or sometimes we call it a summary of the trust. The trust may be several pages long, but this extract may be 1 or 2 pages, and that extract gets recorded in each parish where your trust owns real estate. And on that extract, it states the name of the trust, it states a statement that the trust is revocable, it states the name of the trustee, and other information that's required in our trust code. And in essence, what that does is it lets title examiners know who has the authority to act on the trust's behalf. Okay, so there's your 10 provisions every revocable living trust should have. There are other provisions that perhaps you should have, but I limited it to 10, and everybody's situation is unique. So there's other situations where certain other provisions really are necessary. There's a lot out there on trustee duties, trustee obligations, beneficiaries' rights. So I really didn't get into that. I kind of went with the kind of easy top 10 list of kind of no-brainer, at least as far as I'm concerned, no-brainer provisions that should be in a trust. Okay, just as a reminder, I know I reminded you once before, make sure you hit the subscribe button and the notification bell. So this was a 10 and 5 video. It's a 10 video because there were 10 items or 10 provisions that should be in every revocable living trust. But what I can't get my mind off of is the number 5. At the time that I'm making this video, there's 5 days until my LSU Tigers play in the national championship game against Clemson on Monday night. I'm making this video on Wednesday. I'm going to release it on Thursday because I release and publish a video every morning, 10 a.m. Central Time. So go Tigers. Y'all have a great day. Take care. We'll see you tomorrow.